On October 26, 2025, Sergeant Moore and Officer Christian of the Trotwood Police Department conducted a traffic stop on a vehicle in Trotwood, Ohio. A second vehicle stopped at a nearby stop sign and officers detained its driver. Bentley driver Paris Boyd then pulled up behind that second vehicle and stopped. Officer Christian approached Mr. Boyd's car, and the interaction that followed was captured on his body camera.
Hey, if you don't want to be part of this stop, I suggest you keep going.
Turn your car off. Turn your car off. Turn your car off.
John Victor Queen, 8574.
Okay, may I see it, please?
JVQ 8574.
Are you with them?
I don't answer questions.
Okay, you don't answer questions? Well, leave the scene before you become part of the traffic stop.
Behind the car, so.
Okay, well, you can cut.
I don't answer questions.
Okay, well, you're now part of this traffic stop.
Yeah, I ain't part of it.
Okay. I need your ID.
Hey, no, I ain't got what I'm being stopped for. Am I being detained?
Now you are, yeah.
For what?
Because I told you to leave this scene.
Let me make sure. You'll be famous like Dayton police.
Yeah, that's fine. Give me your driver's license.
I ain't got what I'm being stopped for.
Because I told you to leave this area, cut through that parking lot. I'm telling you to cut through that parking lot.
What through what parking lot?
Okay. I'm going to ask you one more time to give me your license, or I'm going to get you out of the car.
Go ahead.
I'm going to get you out of the car.
Go ahead. So you threatening? I just want to know if you.
It's not a threat.
I'm just saying, you threatening?
I'm giving you a lawful order to give me your ID.
Oh, when I'm at the time?
I'm telling you to leave the scene. And you're still sitting here. I'm telling you to cut through the parking lot. Okay, that's it. Come on.
Officer Christian tells Mr. Boyd that he is issuing a lawful order to provide his identification because Mr. Boyd refused to leave the scene by cutting through the parking lot. Two statutes govern when an officer may lawfully demand identification in Ohio. Section 4507.35 of the Ohio Revised Code requires a driver to present their license upon demand during a traffic stop. And Section 2921.29 requires an individual to provide their name, address, and date of birth to an officer who reasonably suspects them of a criminal offense. Now, at this point in the encounter, Mr. Boyd had not been subjected to a traffic stop, as he had pulled up behind a driver who officers had detained and stopped of his own accord. The basis that Officer Christian offered for the ID demand was Mr. Boyd's refusal to comply with his directive to cut through the parking lot and leave the scene. Section 2921.31 of the Ohio Revised Code prohibits individuals from taking any action that hampers or impedes a public official in the performance of their lawful duties with purpose to prevent, obstruct, or delay the performance by a public official of any authorized act within their official capacity. As the 6th District Court of Appeals of Ohio explained in the 2025 case of State v. Haas, in order to sustain an obstruction charge, the state must establish that the defendant acted with the purpose to prevent, obstruct, or delay a public official, and that the defendant's conduct actually hampered or impeded the official in the performance of their duties, making those duties more difficult to carry out. Therefore, to determine whether Officer Christian had reasonable suspicion to believe that Mr. Boyd was obstructing official business, a court would have to consider whether Mr. Boyd's presence on the scene after being directed to leave, without any other affirmative conduct, was sufficient to satisfy both elements, that he remained with the purpose to obstruct, and that his presence actually hampered or impeded the officers in carrying out the traffic stop.
Don't go through my door.
I will break your glass if you...
Break it. You go to jail.
Hold on.
You gonna go to jail. Break it. You will be on the news. I'm gonna call my lawyer and you will be sued.
Okay,
Tell
sir.
him he break my glass. He'll be sued.
Okay, sir.
I can't leave.
Sir.
Well, who's that?
My name's Sergeant Moore, Trotwood Police
You want me? Tell him he'll be sued. Tell him that crazy.
Okay,
You want to.
okay, sir. Now you are being stopped.
Stay in your car.
I said I'll be entertained. He said no.
You're being stopped.
I can't get through
okay.
this car right
Okay, listen to me.
All right, listen.
Okay, now you're being stopped for your tent.
Okay.
Okay, I need to see your ID.
Okay.
Now.
And what crime I committed?
Tent violation.
Okay, tent violation.
Okay, put your car in park.
It's in park.
Okay, need to see your ID.
I don't answer questions, sir.
Step out.
Ain't no step out.
Okay.
What I do?
I need to take your ID out. Okay.
Come on, I can't take.
Yes, I can, sir. I asked you for your ID. Now step out of the car. Step out of the car.
What's the name?
Step out of the car, sir.
Take my ID.
Step out of the car, sir.
can't take my ID, though.
Yes, I can, sir.
You can't take my ID out my hand.
Yes, I asked you for your ID. I'm illegally stopping you.
You can't bust it.
Okay.
What's your business? Don't touch me. Don't
Okay,
touch
sir.
Me. I'm touching. I'm
Sir.
taking my ID. I'm sorry. I'm just.
Sir.
I'm complying.
No, you're not.
I'm declining.
No,
Can't
you're
take my
not. Pennsylvania versus Mims.
And you can't keep saying that Pennsylvania, because y'all being sued right now. Don't touch me. I ain't touching me. Don't touch me.
Don't put your hands in my face.
Don't touch me, bro.
Do not put your hands in my face.
You will be sued, bro.
Turn around.
You will be sued.
Turn around.
You will be sued.
Turn around.
You will be sued. Go
Turn
ahead.
around. You're being detained.
What's the name?
Put your hands behind your back.
For
You're
what?
being detained.
For what?
Because of what you're
Don't
asking,
touch me.
sir.
Don't pull away from me. I'm not pulling away. I'm not pulling
Calm
away.
down.
I ain't pulling away. I ain't no
You
pulling
are
away.
pulling away. Stop.
Get off my coat.
Stop.
Come on.
Stop.
You know I got a complaint on your.
Stop.
I got a complaint on you already.
Okay.
What's the name?
Sergeant Moore informs Mr. Boyd that he is detained for a window tint violation and orders him to produce his identification. Mr. Boyd opens his wallet and displays his license, at which point Sergeant Moore takes it from his hand. Mr. Boyd protests that the officers cannot take the license from him, exits the vehicle when ordered to do so, and retrieves his wallet. The officers then direct Mr. Boyd to turn around and place him in handcuffs, stating that he is being detained based on the way that he's acting. Now, the statute governing driver's license production during a traffic stop is Section 4507.35 of the Ohio Revised Code, which provides that a driver must, quote-unquote, display their license upon demand and shall not refuse to do so. The statute does not use the word surrender or require that the driver physically relinquish the license to the officer. Accordingly, whether displaying a license within a wallet satisfies the statute's requirement or whether an officer is entitled to physically take possession of it is a question that the statute does not cleanly resolve. Now, regarding the officer's decision to handcuff Mr. Boyd, where officers have probable cause to believe that a crime has been committed, courts generally find the use of handcuffs to be constitutional. Where probable cause is absent and the detention remains investigatory, the use of handcuffs does not automatically transform a reasonable suspicion-based detention into a de facto arrest requiring probable cause. However, as the Sixth Circuit Court of Appeals, which has jurisdiction over Ohio, explained in the 2015 case of Brown v. Lewis, a bare inference or speculation that a detainee may somehow be violent is not sufficient to justify handcuffing, and officers must point to a specific reason to believe that the detainee poses a risk of flight or violence. Importantly, the court recognized that an unarmed detainee who displays aggressive, erratic, or nervous behavior during a stop may give rise to a reasonable belief of dangerousness sufficient to justify restraints. Here, the stated justification for Mr. Boyd's handcuffed detention was his verbally combative and argumentative behavior. Accordingly, it is possible that a court could conclude, based on this precedent, that handcuffing Mr. Boyd was constitutionally reasonable under the circumstances, even if the officers did not have probable cause at the time that he was handcuffed.
Huh?
Yeah, I got a complaint on you.
Sure, okay.
You ain't supposed to be doing this. I already got a complaint on you.
I don't know you from Adam, sir.
You know me. You don't tell me. This your third time. I'm not doing nothing. I'm right here. You don't got to hold me tight.
Okay,
you ain't gonna
sir.
do nothing, but let me know. I ain't no sir. You know I got a complaint on you, Connor. Trotwood, I told you stop.
What's my name? My name's not Connor.
What's your name? It's over the seat.
No, it doesn't, sir.
I got you. What's your name?
Okay.
Stop throwing my stuff on there.
Stop. Stop.
I'm not moving. I'm good. Come on. Come on.
McDaniel, if we don't need them, kick them loose.
Yeah. Come on. He been what's his name? But it's all right.
Okay. Again, I've already identified myself. My name is Sergeant Moore.
Moore?
Yes, sir.
We done ran into each other.
No, sir. I don't know you from Adam.
You're not a sergeant?
Yes, I am.
Okay.
Stop.
I don't matter.
Stop. Okay. I don't know you from Adam.
You know me.
Okay. The way you're acting is why you're in handcuffs right now.
No, because he gonna tell me to go through.
Sir.
I'm not taking my car through no what's the name. And
Okay.
I gotta wait till the car to get through.
You got a temp violation, and that's a legal reason to stop.
Ain't no look, you can't stop me if you ain't got
Yes, I do. And it'll be. So what's happening right now? You're gonna walk over and have a seat.
Y'all don't make one. That's what we're
Okay. All right. Walk over here.
Y'all be fine. Y'all date 3
Okay, sir. All right. So, hey, the reason you're in handcuffs is because
The reason because y'all want to buy a black man.
Sir.
I don't care about nothing.
Sir.
Stop touching me like that.
Sir.
Stop holding me like that.
You obstructed official business. You were.
How?
Because he asked for you to multiple
He
times.
told me to go through the truck. I said I'm not going through there till car move.
Okay.
All right.
Okay. Legal
I'm not
reason to
going
stop
through
you.
that.
Okay. Legal reason to stop you is for the
bothering
tip.
a black dude. You racist. You're both
Okay,
racist.
I don't know
You're
you, sir.
racist.
Sir, release the car. I'm going to search your
racist.
pockets.
All right.
I know you can't search me. That's against the law.
Sir.
You cannot search me.
Okay.
I didn't do nothing.
Okay.
I tried to stop. It's not searching.
I have a reason to search you.
What?
I can pat you down by the way you're acting,
You can't
sir.
do that. Stop ripping
Yes, I
my
can, sir.
pockets. Stop ripping my pockets.
Nobody.
Stop ripping my pockets.
Okay, sir. Stop.
Yeah.
Stop.
Stop ripping my pockets.
Have a seat.
Stop reaching my
Stop. 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 Have a seat.
Tell him he'll get sued.
Huh?
He will get sued. Tell him.
Okay.
Yeah, you can't do that. No, you can't take my phone.
Yes, I can, sir.
You cannot take my phone.
Yes, I
That's my
can,
property.
sir.
I'm recording.
Okay,
I'm
sir.
recording you.
Take
I'm
your phone.
recording. I'm recording you.
Okay.
I'm
We are
recording.
too, sir.
I'm recording.
We are too,
I'm
sir.
recording.
Have a seat.
Hey, we're recording
too. Sit down. Sit down. Sit down. Sit down. Sir, sit down.
How can I get in here?
Let's see.
Yeah, can't do don't touch me, bro. I'm in here though. He's fucking.
Everybody wants to come here to this traffic stop.
Everybody's just pulling up.
Yeah.
Oh, okay.
Hey, buddy, I'll try to stay with them since he's
All
over.
right. You will be on, what's the name?
You don't even know what it is. Stop talking.
Don't even worry about it. You a sucker. Cold sucker. Tell you a rookie, because you don't even know what you're doing. Can't pull me out my car, none of that. Make sure we go to court for everything. Make sure you have y'all pins together.
Okay.
While seated in the back of the cruiser, Mr. Boyd informs the officers that they had no authority to remove him from his vehicle. In the 1977 case of Pennsylvania v. Mims, the Supreme Court held that once a lawful traffic stop has been initiated, an officer may order the driver out of the vehicle as a matter of course, with no additional justification required. Here, the window tint violation had been identified prior to the order to exit the vehicle, providing an objective basis for the stop. Now, although the window tint violation was not the original reason that Officer Christian approached Mr. Boyd, and it is possible that the officers would have ordered him out regardless of any traffic infraction, the Supreme Court determined in the 1996 case of Wren v. United States that a traffic detention is constitutionally valid so long as officers have probable cause to believe that a traffic violation has occurred, regardless of the officer's subjective motivations for making the stop. Therefore, as the officers had identified a traffic violation at the time that they ordered Mr. Boyd out of his vehicle, a court would likely conclude that they did not violate the Fourth Amendment by doing so.
What's the name? Amen. Hey, what's your name, Sergeant? Officer?
Officer Christian.
Officer Cruz?
Christian.
What's your badge number?
166.
Okay. Make sure you give me your card with your name on.
Yep.
And make sure you go viral.
Cool.
Your body cam on?
Yes, sir.
Okay. You go viral.
Cool.
Yeah.
Go ahead.
I was seeing that.
Just because we are
You know what I'm saying? You be next.
Can you check and see if Trotwood has an operator available?
Yeah, I don't even got no tent thing. How you gonna pull up somebody with a tent? Ain't even got a tent in there.
PA-20, less than.
Do his citation. Your tent is at 2%, sir.
Hey, don't worry about it. I need your ID number too.
Hey, it's 85.
Okay, make sure you give me your badge number.
Hey, I just did. It's number 85. It's 85. I don't have a card on me, sir. I told you it's 85. He's going to be cited for the tent violation, and he's going to be start the order in for disorderly conduct.
Okay.
Okay.
I show up
Cool.
with a
Okay, hey, sir, I got a canine en route.
I don't give a. I don't.
I'm trying to explain to you, sir, what's happening.
I don't search a, I don't condone search.
Okay, well, I'm telling you, a canine is en route. If the canine alerts on your car, then we will be doing a search of your car.
Sergeant Moore directs Officer Christian to issue a citation for the window tint violation and an order or summons in lieu of arrest for disorderly conduct, and then informs Mr. Boyd that a canine unit is en route and that if the dog alerts on his vehicle, a search will follow. The Supreme Court addressed the constitutionality of dog sniffs in the 2005 case of Illinois v. Cabayas, concluding that a dog sniff conducted on the exterior of a vehicle during a lawful traffic stop does not implicate the Fourth Amendment because a well-trained narcotics detection dog reveals only the presence of contraband in which no person has a legitimate privacy interest. The Supreme Court clarified the limits of that rule in the 2015 case of Rodriguez v. United States, holding that a traffic stop becomes unlawful if prolonged beyond the time reasonably required to complete its mission, with the critical question being not when the dog sniff occurs relative to the issuance of a ticket, but whether the sniff adds time to the stop. Now here, the citation and summons were still being processed at the time that the canine was called, meaning that the stop's mission had not yet concluded, and a court would likely find that a sniff conducted during that window did not unlawfully prolong the stop. Additionally, when a canine, quote-unquote, alerts or signals through a trained behavior that it has detected the odor of a controlled substance, that alert would generally establish probable cause to search the vehicle. In the 2013 case of Florida v. Harris, the Supreme Court determined that a dog's alert provides probable cause to search if the dog's reliability is established through evidence of its training and its certification record. Accordingly, as long as Mr. Boyd's detention was not unlawfully extended beyond the time required to process the citation and summons, a court would likely conclude that the officers were within their Fourth Amendment authority to deploy the canine, and, if the dog alerted, to conduct a full search of the vehicle's interior.
Y'all be soon. Ask Sergeant Wilson. I'll make sure he tell y'all about him.
Who?
Don't worry about it. Yeah.
Who?
You know.
No, I don't.
Yeah, don't worry about it.
Okay.
Make sure I want to call him. Yeah, he was in there. Yeah.
Do the obstructing check. Yeah. Do the obstructing. Actually, he can go to jail for the obstructing.
Well, I'll take him to jail for obstructing.
Yeah. Well, right now we'll do the order in.
Okay.
Do the order in for the obstructing, disorderly conduct, and his citation.
I gotta get his tag real quick.
Okay. It should be in the call, but they didn't add it? Mm-mm. Okay.
Did you, when you took his wallet, did you,
No, I
got his ID.
You got his ID?
Yeah.
Okay.
Whatever you got it on, it sound good?
Cool. Thank you.
So that's where we're getting the obstructing because we're asking him for his ID, and he's trying to show me with,
Okay.
hey, it's right here. No, I have to take it out. No, I don't have to.
Yeah.
You do. So we'll do the, do him for the obstructing, and we'll go from there.
Okay, so I'm charging him with obstruction then?
Yes, obstructing disorderly conduct.
As an order in or?
As of right now,
Okay.
we still got the canine en route to do the 3 years.
Sergeant Moore directs Officer Christian to initiate an order in lieu of arrest for obstructing official business, citing Mr. Boyd's refusal to physically surrender his driver's license after displaying it in his wallet. As discussed earlier in this episode, Section 2921.31 of the Ohio Revised Code prohibits any person from taking an action that hampers or impedes a public official in the performance of their lawful duties with the purpose to prevent, obstruct, or delay an authorized act within the official's capacity. The 6th District Court of Appeals of Ohio addressed a similar issue in the 2022 case of State v. Kelly, holding that a defendant's refusal to provide a driver's license upon request does not constitute obstructing official business because the mere refusal to comply without an affirmative overt act is insufficient to sustain the charge, and that while a motorist's failure to produce a license may constitute a separate violation of Section 4507.35 of the Ohio Revised Code, that same conduct does not rise rise to the level of obstructing official business. Accordingly, if an outright refusal to produce a license cannot support an obstruction charge, displaying a license but declining to physically hand it over presents an even weaker basis for that charge, and a court applying this precedent would likely conclude that Mr. Boyd's handling of his license did not rise to the level of obstructing official business.
Add him to the call. What's his name? I don't know this guy. He swears up and down.
I don't even think he knows where he's at.
Yeah.
Freaking goofball.
Oh, I know. Paris Boyd. Yeah, I know who he is. That's what I thought that was him.
No.
Find him.
Yeah.
Well, he's got more stuff.
No. Paris Boyd.
I decided to in that car.
Hey, Paris, you're right. I do know you, and I have cited you for this in this vehicle.
I know you know. Yeah, don't worry about it. You're harassing me right now. I wrote
It's
you
not
out.
harassment.
Yeah,
Sir.
you're harassing me, bro. Same time. Make sure you holler at my judge. You know who I am, and I know who you is. Same person. You know who I am. Yeah. Chasing you young punks, the same thing. Chasing these young dummies, the same thing. How to arrest people. Luck ain't never gonna be no good, man.
Paris, you're being charged with obstructing and disorderly conduct and the citation.
Don't worry about it. You're going to hear from my attorney. You hear? Yeah. You the same police officer bothering me all the time. I know. Being charged with nothing. Obstruction. Of what? It's on tape. Everything on tape. So, y'all body cam don't lie. All right, now he know who I am. I know. He's saying why I made a complaint. Like, what's your name? You said your name was? Huh?
I already told you.
You said who?
So I already told you.
No, I don't know. You got to repeat yourself.
I don't have to.
What is it?
I already told you.
No, what's your name? I'm asking you what's your name.
I already told you what
So
my
you're not
name
gonna
is.
tell me? What's your name? You're not you
I already told you.
Under law, you got to tell me who.
Under what?
What? Under law, you got to tell me who your badge and what your name is.
I already did.
What is it?
I already did.
Yeah, you playing games. Don't worry about it.
Yeah, all right.
You got to write this ticket up. You'll be the same one on the face with him.
That's fine.
You know.
I'll see my name on the ticket.
What?
You heard me.
No, I didn't hear you.
Okay, well, clean your ears.
Said what? You torrent. Cold sucker. You ain't shit without that badge. I'll tell you that.
Okay.
Hiding behind the badge. You're a coward. That's all you is.
Okay.
They go back and lie to your chick that's cheating on you. She probably with somebody right now.
Pretty generic, dude. Come up with a new
Probably
one.
with somebody right now, man. Cold coward. You think you tough? Don't worry about it. You hear from my attorney. The show.
Hey, Paris, I'm not searching your vehicle unless the canine
know
alerts on the
what's
car.
going on.
But I am asking you right now: is there any guns, drugs, anything like that in the vehicle?
I don't consist of search citizen. I don't answer no questions.
Okay, all right.
I know. I know my rights. Hope you got a good lawsuit. What's your boundary?
He already told you.
Yeah. It's to your boss. He'll tell you. Your boss. And I requested a lieutenant over him. Give me your lieutenant out here ASAP.
A what?
Your lieutenant.
Oh.
Come out here. Do I gotta say it in Japan, English? What? Can you
preferably
understand?
English,
Can you
yeah.
understand? Because you act like you can't understand. Get your lieutenant out here. Matter of fact, yeah. Make sure you go viral.
You already said that.
I'm gonna say it again. Make sure you go viral.
Okay. You're like a broken record.
It be you police officers messing up for the good.
Mm-hmm.
Yeah.
Hey, did you pull a separate case report?
Hey, he can still pull a second. Hey, he can still pull a second.
I know.
No, not yet.
Okay, you're gonna have to pull a second case report number for this other. It's gonna be considered a separate.
Okay, gotcha. So I can do it from the same call, though?
Yeah.
Because it's been from the same call. Gotcha. What kind of Bentley is that? Besides old.
I'm not sure.
Doesn't say. Just 4-door.
I know, but for the solve, it wants a model. What's that? W12. I don't know if that means anything. No, I didn't even bother asking him.
Try W12.
Thank you.
Stop messing with me, bro. Stop messing with me, bro. I'm doing good. He want to tell me, he want to try to throw me with that, man. Stop messing with me. All we got to relate. I got to already. It's him, though. I got to relax, George. I'm gonna send it to the people. They gonna get famous. That's all. They'll be on YouTube. No, relax. That's what I was telling them. Hello?
Yes, sir. You can't sign in on the 11th because it's Veterans Day.
No.
Okay.
I'm going to pull my cruiser off sail and put it over here. I'll be right back.
Mr. Boyd was charged with obstructing official business, disorderly conduct, and a window tint violation. He retained counsel and entered a plea of not guilty on all charges. And as of the date of writing this episode, all charges remain pending. Overall, Sergeant Moore and Officer Christian get a C- for exercising poor discretion in escalating a routine encounter into a custodial detention, pursuing an obstruction charge that controlling case law does not support, and conducting themselves in a manner that was unnecessarily combative and antagonistic throughout the encounter. The window tint stop, the exit order, and the K-9 deployment all rest on defensible ground under established precedent. And the handcuffing, while debatable, is not without legal support given Mr. Boyd's persistent verbal combativeness. What is more difficult to defend is the officer's judgment. Mr. Boyd initially did nothing more than stop his car behind another vehicle. Whatever legal authority existed to order him to move along, the decision to transform that moment into a detention, a custodial handcuffing, and multiple criminal charges reflects a significant failure of proportionality. The obstruction charge premised on Mr. Boyd's handling of his license is particularly difficult to square with the 6 appellate districts holding that an outright refusal to produce a license does not constitute obstructing official business. Beyond the legal analysis, the officer's demeanor throughout this encounter was dismissive, condescending, and at times openly contemptuous, none of which served any legitimate law enforcement purpose, and all of which contributed to an escalation that a more measured approach could have avoided. Mr. Boyd gets a C+ for refusing to comply with officers' directions in a manner that escalated the encounter, demonstrating a lack of understanding of his legal obligations during the stop, and engaging in persistently combative and unproductive behavior that undermined otherwise valid legal arguments. Mr. Boyd's initial conduct was entirely unremarkable. He stopped his car behind a vehicle that was stopped in front of him. However, Mr. Boyd's persistent verbal combativeness, refusal to engage cooperatively, and escalating hostility throughout the detention, it gave the officers the justification they needed to sustain a handcuffing that might otherwise have been difficult to defend. Likewise, Mr. Boyd's objection to being ordered out of the vehicle reflects a misapprehension of the law. The window tint violation had been identified before the exit order was issued, and once a lawful traffic stop is underway, officers officers may order a driver out of the vehicle without any additional justification. His resistance to that order, however understandable emotionally, was not legally grounded. Mr. Boyd was not without valid legal arguments in this encounter, and the obstruction charge brought against him is difficult to defend given the relevant case law. However, his conduct throughout the encounter made it significantly harder for those arguments to succeed, and it transformed what could have been a brief stop into a prolonged custodial detention. This interaction highlights how knowing your rights and effectively exercising them are two distinct skills, and that combative behavior, even in response to questionable police conduct, can erode the legal footing of an otherwise legitimate grievance. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out Audit the Court if you're interested in exploring the legal nuance beyond the body cam.